Guys. Bridget, you already know, huh? It is a mess. Let me know if you guys can hear me okay. Bridget says this is a mess. I believe her. She's right. You guys can hear me fine. Hey, Burden, Stardust, Queens. Hopefully, quickly, somebody says, no, I can't hear you. Yes, I can hear. Great, good. Loud and clear. Nice. I just turned my AC on. It needs to kick in immediately, if not sooner. So this is something out of Boston. Whew. And as Bridget above said, it's something. I've been following it for a few days. If I bump up the sound, it'd be great. I'll just try and talk a little louder. What is a mess? Well, so I've been following this on a page that I used to follow when I lived in Boston. And it came up because I still follow the Boston news. So it comes up and I'm like, that sounds interesting. So I start to read about it. Oh my gosh. When I take you down this rabbit hole, you are going to be like, what in the world is happening there? This gentleman here, John O'Keefe, he was a 16-year veteran of the Boston Police Department. Okay. He was killed on January 28th of 2022, or the early morning of January 29th, 2022, right? So he was dropped off at a friend's house. I'm going to take you through this timeline, and then I'm going to fry your brain. I'm going to fry your brain for a little bit, because mine's been fried. And then I will give you the resources to the people that I've been following on it, so that if you want to follow it too, you can do that. But wow, it's crazy. So that's John there. This is Karen. Okay. Karen had been dating John for a couple of years, and they were the two who were out together that night. They went to a couple of bars, and they'd been drinking, and they met up with some friends, other cops, that type of thing. And Brian Albert, who's also in law enforcement, was the house that they were going to go to after. But she had a stomach issue, so she was just going to drop him off and then go home. And she figured it's not that far. He can just get dropped off, right? So he was dropped off right around 12:15. Now, keep in mind, Brian, the house, you saw this on TV the other night. Brian is a police sergeant, okay? So she goes, she drops him off, she leaves. John's watch, you know, your Apple Watch is everything that you do. Your Apple Watch knows. It's listening to you. It's watching you. So his watch recorded him taking 80 steps, allegedly, between 12:21 a.m. and 12:24 a.m. They said that he climbed the equivalent of 3 floors. Then between 12:31 a.m. and 12:32 a.m., he took another 36 steps. His location was right in the proximity of Albert's residence. So how many of you have an Apple Watch? I have one. It doesn't record steps that I don't take. It can record movements, and we'll get to that part in a little bit. But if you're sitting all day, or if you're sleeping, or if you're laying down, it is not recording shit, okay? It's not recording a damn thing. They're very smart. Hey, Trasha. I'm going to show you what went on in court, too. Nanya, what do you think? They record. They record what you do. Run up and down the stairs. It knows how many flights of stairs that I take in a day. It knows. So we'll get to why I'm even talking about that. This is the house, okay, in Canton. I'm going to try to be as non-Boston as I can, and I'm going to pronounce all the words. In reading all of this, I just finished reading 32 pages. I could hear myself reading it in my Boston accent, and I said, no, because people aren't going to understand what the hell you're saying, so you got to slow it down. 34 Fairview Road in Canton, Mass. This is the home of the police sergeant. Now see, I said sergeant, yeah? Not sergeant, which I normally would say. Brian Albert, right here. This is his house. Was. So, Brian is one of the... there's a fugitive squad in Boston. It's not finest. It's not working. Well, he's one of the fugitive squad members in Boston, right? Finest would know about this. Bridget, Ashley, you guys know about the fugitive squad in Boston. He's been doing it a long time. Anyway, this is him, right? And that was his house. And that's where they were going, allegedly. This lieutenant lives on the same street as our friend Brian, right? So now you got Brian and you have the lieutenant. And they live on the same street. Sadly, he had no Ring camera footage to help anything, but in any case, I just figured I'd mention him. Who was in the house this night? You've got Brian, the sergeant, right? Brian's son, Brian Jr., Brian's nephew, Colin, Brian Higgins, there's a lot of Brians, the federal ATF officer, John O'Keefe, who passed away, and Matthew McCabe, brother-in-law to Nicole. We're going to get to Nicole. Nicole is the wife of Brian. They're married, right? These are their kids, Brian and Caitlin. Julie is a friend of Brian's, and Sarah is a friend of Brian's. Jennifer McCabe, wife of this dude, Matt, and sister of Nicole. All right? So these are the people. Some of them were out drinking. They all decided they wanted to keep it going a little longer, and they went back to this sergeant's house. Okay? While they were still at the bar, Karen and John were invited back. And they said, okay. But Karen has some stomach issues normally, and she didn't really want to go. So she just dropped him off there. Okay. Karen is arrested for John's death. Okay. After several days of intensive investigation, detectives from the Norfolk District Attorney's Office late today obtained an arrest warrant for Miss Reed. This is according to the DA. We expect that she will be arraigned close to 9 a.m. tomorrow, February 2nd, 2022, in the Stoughton District Court. Additional narrative information may be put into the record during the arraignment tomorrow. Tonight, our thoughts are very much with those whom John left behind. Okay. They're thinking somehow she killed him. Well, where is he? What happened? How did this happen? Right? Well, we're going to get into it. What did the witnesses say happened? So we're going to go look. We're going to look at what these witnesses say occurred. Let's go over here real quick. This is a lot's gone on so far already. And she does have very good attorneys. We're going to play some of that. Okay. You guys seeing this? This is a surprise. Yes, it's a surprise for Sunday. All right. Because this case is so interesting, I'm like, I gotta come on and talk about it. I have to. So, January 29, 2022, 6:04 a.m., the Canton police receive a 911 call from a woman reporting a male person, subsequently identified as the victim John O'Keefe, found in the snow outside of 34 Fairview Road. At the time of the 911 call, there was an active blizzard occurring. At the time of the 911 call, not, 7 hours before it, but at the time of it, so it's 6 in the morning, there was an active blizzard happening. The temperature was in the teens. Officer Saraf and Mulaney, both of the Canton Police Department, were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first officer to arrive on the scene, where he observed 3 females waving at him from the front yard of the residence. The camera cruiser footage was reviewed by a grand jury and admitted as Grand Jury Exhibit 56. The footage depicts the weather and visibility conditions during the officer's transit, and it's hard to see. Unless you've really been in a snowstorm, you don't really know, but it's rough, right? So what exactly happened? What is Karen saying happened? She thinks she dropped him off at his friend's house. She went to bed. She gets up throughout the night. She's looking for him. She doesn't know where he is. And she's texting him. She's messaging him. She gets really nervous. So she calls one of the ladies who was at the party. But we're going to get there. The three females on the scene were Karen Reed, Jennifer McCabe. Now, I told you guys who Jennifer McCabe was. And Kerry Roberts. She was giving him mouth to mouth. She didn't know what the hell was going on. What was happening here. We're going to move from the scene and we're going to go to what they said. Later that morning, Massachusetts State Police Detective Unit was notified. The district attorney, everybody's notified. Trooper Proctor and Buckenick were among the troopers who responded and began interviewing. First, they interviewed Miss McCabe. Miss McCabe said that she and some friends were at the Waterfall Bar and Grill during the evening of January 28th. She arrived with her husband, Matthew. So remember, it's Matthew and Jennifer. Matthew and Jennifer. At around 9 o'clock. They were just getting out of one of their kids' high school football games or basketball games. Around 11, Mr. O'Keefe and Miss Reed arrive at the waterfall together. Miss McCabe stated that Mr. O'Keefe and Miss Reed have been dating for approximately 2 years, and Miss Reed stayed at O'Keefe's house most nights. McCabe observed Miss Reed walk into the bar holding a glass cup from C.F. McCarthy's with a clear liquid inside. She thought it was a vodka soda. Miss Reed had entered the waterfall glass with the glass inside her coat. Mr. O'Keefe and Miss Reed had been at C.F. McCarthy's, a bar across the street from the waterfall, prior to coming there. Miss McCabe observed Mr. O'Keefe to be wearing a baseball hat, jeans, and sneakers. She stated that the defendant and the victim were in a good mood. There were no arguing. Everything seemed fine. No problems. She further described the atmosphere within the bar as very friendly. Nobody was in a bad mood. Everybody was great. The description of the whole group and the atmosphere within the bar and the defendant and the victim, everything was consistent. Nobody saw anything on the cameras that looked strange. Everybody looked all right. As the bar began to close, everybody within their group was invited back to 34 Fairview Road, the residence of Miss McCabe's sister, Nicole, and her husband, Brian. She observed Mr. O'Keefe and Miss Reed leave the waterfall together. As Miss McCabe was arriving to her vehicle, she received a text message from Mr. O'Keefe asking where to. This was 12:14 a.m. Miss McCabe replied with the address 34 Fairview Road. At 12:18, he called her to ask more specifically, where's this house located? While inside the residence, following her arrival there, she looked out and sees a black SUV consistent with Miss Reed's vehicle. She has a 2021 black Lexus SUV. It arrives in front. From her vantage point, she was at the front door of the house. She texts John, who's in the car, right? Hey, Mad Feathers. So she's in the car. John and Karen are in the car together. And McCabe's at the front door. Yeah, Jax, hold on. My sources are all up here. As you can see, TB Daily News right there. TB. I know who Turtle Boy is. I followed him for years and years, of course. If you're from Boston and you don't know who Turtle Boy is, then I'm not really sure. I'm not really sure if you're from Boston then. Turtle Boy covered when he was Turtle Boy. He's kind of, he's still Turtle Boy, but he's doing a lot of different things now, right? But he covered my ex's best friend's daughter when she was out drugging and doing all the things. He used to cover her, and so I always read. That way I could keep up with what she was doing, because he literally knows everything. If it happens in and around Boston anywhere, he knows about it. So, yeah, he's done really well with this. We'll get to that part too because some people will be able to handle Turtle Boy who come in here. Some will not be able to handle him. That's just how it is. So, anyway, McCabe texted John at 12:31 a.m. stating hello. Now that's at 12:31 because she sees them in the car. Yeah, it used to be the Ratchets, yes. So she's looking out the door, allegedly, and she sees their car, and she texts him instead of just walking down the driveway and saying, hey, park over here. She texts him, hello. Then 9 minutes later, pull up behind me. 9 minutes later? Okay. Referencing her vehicle's parking spot within the driveway to the home, located on the right side of the property if looking at the residence from the street. That's 9 minutes. So are they just sitting in the car talking? I don't know. So Miss McCabe, then observes the SUV move from its initial place where it had stopped on the street near the driveway, proceed to the left side of the property where John's body was subsequently discovered later in the morning. Now it's 12:45 a.m. Miss McCabe texted Mr. O'Keefe again, hello, and then observed the black SUV drive from the home. Now you tell me what you think is going on right there before I tell you anything else. Okay? I invite people back to my sister's house because we're all going to hang out and drink some more, right? So you, me, and John, I'm McCabe, right? John texts me and says, where to? At 12:14 in the morning. And I say, 34 Fairview Road. 4 minutes later, John calls. Well, where exactly is Fairview? So then I tell him. I get to my sister's, I get out, and now I'm waiting at the door for you. I'm waiting for you and your girlfriend to pull up, right? Okay. I see you pull up at 12:31, and I text you again, hello. I wait 9 minutes in the doorway. 9 minutes in the doorway? Because you're saying hello at 12:31 a.m., right? Because you're looking out the door. You're at the door. And it's freezing, so okay, maybe you don't want to walk down there. Hello. You wait 9 minutes? And then say pull up behind me? Okay, fine. Now you're watching the vehicle. Do you see, I'm looking. Do I see John get out of the car? Doesn't say that. It just says, McCabe then observed the black SUV move from its original place near the, and it's moving away now. Okay. But at 12:45, again, I text, hello, but I'm watching the car drive away. Not hello with a question mark, like, oh, why are you leaving? Hello. Just hello. But now the SUV's gone. So what do you do then? Do you text and say, hey, where'd you go? Do you open the door to let him in? What do you do? Well, according to her, nothing. Not so. Now we're going to move right along here, right? 4:53 in the morning. Hours later. This is now 4 hours later. 5 hours later. She gets a call. 1 second. Okay, so back again. Here we go. It's 4:53. She gets a phone call from Karen looking for Mr. O'Keefe. Please keep this part in mind. Please keep this specific part in mind. She gets a phone call from Karen. Have you seen John? The phone call was placed by the victim's niece. Now, let me explain this part. John had custody of his niece and I think, or two nieces or niece and nephew. Either way, his niece and nephew or nieces lived with him. One was over at a friend's house. The other one was at home with Karen. So Karen has the juvenile niece call Miss McCabe's phone. She ends up getting on the phone. She's distraught. She's freaking out and says she's coming over there. She tells Miss McCabe she last remembered seeing the victim at the Waterfall Bar. Huh? What do you mean? What are you talking about right now? Why would she call you then? Why did she call you looking for her man if the last time she recalled ever seeing him was at the bar? Why would she call you? That makes no sense to me. It's one of the things that I highlighted because she's calling you like, do you have any idea where John is? Last I remember, I saw him at the bar. Well, why would she know where your man is then? That makes no sense whatsoever. But in any case, Miss McCabe then informed Karen that she observed Karen and John leave the bar together. She also later informed Karen that she had seen them in Karen's vehicle in front of the house on Fairview. Karen then informs Miss McCabe that she and the victim had gotten into an argument the last time she saw him. The last time she recalls seeing him was at the Waterfall Bar, allegedly, according to Miss McCabe, right? So if the last time she recalls seeing him was at the bar and they got into a fight, why isn't that on camera? Why don't the witnesses recall that? Why don't the people who were spoken to recall that? I don't know. Well, could it be because people are not telling the truth? Perhaps. Perhaps. Karen arrives at McCabe's house just after 5:30 in the morning. Shortly after Karen arrives at McCabe's home, Kerry Roberts arrives as well. She had also received phone calls from Karen early that morning looking for John. McCabe then drove Karen's vehicle from her house, her meaning Reed's house, back to John's house because she was hysterical and she couldn't drive, allegedly. So Miss Roberts followed along in her own car. While driving to John's house, now, please, anybody, explain this to me. Karen leaves her house, right? And arrives at McCabe's house. Kerry also arrives there. Then McCabe brings Karen back to her house, back to John's house where they were staying. Aren't you supposed to be out looking for him? What are you doing? So you're going from your house back to the house that she just left that he's not in. But okay. While driving to John's house, Karen states to McCabe, "Could I have hit him? Did I hit him?" McCabe stated that the defendant also told her about her cracked tail light. Once they arrived at John's home, the defendant, Karen, has Miss McCabe look at the cracked tail light, which McCabe described as the passenger side rear right tail light cracked and missing pieces. McCabe says the defendant then entered Miss Roberts' vehicle to go look for the victim. What? Roberts, who was already with you at McCabe's house. So you're at McCabe's house and you drive with McCabe back to John's house that you just literally left. And Kerry follows you. And then you guys get there. And then you hop in the car with Kerry. Because that's why it happened. Because. You might see why, because soon. Allegedly. So. Kerry drove. McCabe was in the front passenger seat. McCabe stated they turned onto Fairview Road from Chapman Street. At that time, it was snowing heavily. Now, it's snowing heavy. The wind is blowing, poor visibility. If you've ever drove in a nor'easter or a blizzard, you know what that means. You can't see shit. McCabe stated that just prior to 34 Fairview, there's a cluster of trees. Immediately, can you feel my house shaking? That's my husband's car. I hate that fucking car. I hate that fucking car. Okay. There's a cluster of trees, and immediately the defendant stated she sees the victim. She sees him. But this confuses McCabe and Roberts because they can't see him. They don't even see him. It's like invisible. They don't even see him. McCabe stated the defendant screamed to open the door and ran directly over to the body near that cluster of trees and laid on top of him for warmth and began CPR. McCabe stated the victim was laying on his back, covered with approximately 6 inches of snow, with his phone on the ground underneath him. The defendant yelled at McCabe twice to Google, "How long do you have to be left outside to die from hypothermia?" Do you think that that's true? You find your significant other. Maybe you were drunk. Maybe you're thinking in your mind, did I hit him when I was leaving? How fast are you making your turn? Because McCabe just described the turn, right? The car just left. You're not like, no, she did a 3-point turn. You guys, if you're from anywhere in Massachusetts, you know what a 3-point turn is. You can't do them quick, especially on these streets, which I'll show you. So you're thinking you could have hit him, maybe, allegedly. You're laying on top of him. You're giving him CPR. And you turn to your friend or to this woman that you think could be with your husband or your boyfriend because you don't know where he is. Google how long it takes to die from hypothermia. What the fuck? Would you guys do that? No, he wasn't in the woods. He was directly in front of the house. I'm going to show you. You want to see where he was? You're going to see where he was. So ridiculous. It's this whole... I'm reading it. I'm looking at it. I'm looking at the photos. I'm looking at everything that I can possibly look at. And I'm like, this doesn't make a lot of sense to me. This is not making a lot of sense to me at all, right? But you think, well, okay, maybe, possibly, allegedly, it could happen this way, I guess, right? Maybe. Probably not, but it's possible. Let me show you the photo. To grab it. Give me 1 second here. So crazy. And I also want to show you this video too, because never in life. No. No. Mm-mm. Come on, buddy. Where are ya? Photos. I thought I saved this one. I guess I did not, but it shows exactly where he was found. That's so annoying. Did they take it down? Son of a bitch. Of course. This is so ridiculous. Some of the shit that goes on. I don't know how familiar you are with these really tight police departments. And part of me is like, well, could it have happened just like they think it happened? Maybe. Until I look at the autopsy photos again and I'm like, yeah, I don't know. I don't know about this. I don't know about this shit here because it doesn't sound right. Here's one of the photos. Ooh, Turtle Boy has done a great job with this. He put together everything. Do not mess around. All of it. And I'm sure they hate him for this, you know. I'm sure they're like, we hate you for this. Because he's really showing the bullshit that is going on. Let me show you this picture. It's absolutely crazy. It's crazy. See this? Come on. I'm not good at this. I don't know why the hell it opened in paint, but this is the house right here, right? That's 34 Fairview. And out here near the cluster of trees, allegedly, is where this gentleman was found. Keep the flagpole in mind too, okay? The Cliff Notes, Choppa. I wish there were Cliff Notes. I can show you. She got arrested. She is going through court right now. Who is Turtle Boy? I'll explain that too. I can give you some kind of type of Cliff Notes. I don't know what you're going to think of these. But this came from a source on Twitter. And I don't know what the hell you're going to think of this. Let's see. Hold on. Sorry. Good Lord in heaven. There is no short cliff notes to any of this. I wish there was. I really wish there were cliff notes that I could give you. There's just not. This gentleman here, John, right? Boston police officer, goes with his girlfriend, Karen, here. They go to 34 Fairview, here. Brian is a trained MMA fighter. He owns a canine German Shepherd. I've got something caught all the way in my throat, and it's making me nuts. German Shepherd's also gone. Let me get a sucker. Hold on. Sorry, I was gonna choke myself to death there for mother's sake. I had to go get a sucker. It's crazy. He had to be a good person because he had a German Shepherd, maybe. Let me show you this. See what you think of this. Carpet pulled up, everybody moved away. Weird, right? What do you think of this? What do you think of this? They're claiming that she backed up into him. Oh, they gave the dog away. The dog's gone. The house is sold. 34 Fairview has been sold. Yeah. How about these? What's this? What's this? What do you think about those? Remember when I got bit by my dog? I still have some scars. See? You guys had the pictures. Some of you have had the pictures, but very similar to these. Very, very, very similar to this. Backed up into him. Did she back up and drag him? Did she... What? What is this? What is this? So no. There's no summary of this. This is a dead Boston cop. And his girlfriend is being set up. Yep, Jax. Okay, so let's keep going. They're saying the owner of the house and everybody else says John never made it inside the house. He never came in. Well, my question is, if Jennifer McCabe, right here, was talking to him, texting with him from the door where she's looking at the SUV, Didn't she know that he never came in the house? So she already knows that he didn't come in. She leaves the house at 1:47 a.m. Nobody sees him laying on the yard outside. Nobody sees him out there. He's wearing dark clothing. Nobody sees him. Nobody. The people coming in and out and leaving. Nobody sees him. Okay. Allegedly Googled how long to die in the cold at 2:27 a.m. 2:27. Not at whatever time in the morning when she says she did. Let's talk about the rest of the people who were in the house. You got Brian. Everybody in blue here is law enforcement, okay? Everybody in blue is law enforcement. Brian Albert, it's his house. John, he's passed away. Brian Higgins, federal ATF agent, went to complete administrative work at the Canton Police Department at 1:30 a.m. What? Okay. Lieutenant Keller, no ring security footage. Lives. Okay. Ken Berkowitz, Canton police chief at the time of the death, found pieces of a car taillight at the scene from moving car after the scene had been searched already. Do you want to know what they found at the scene? And how they collected it? Sure you do. What do you think that is? What's this? What is that? What the fuck is this? I'll make it big for you. Slushies? Maybe? No. Nope. Not slushies. Red Solo drinking cups. There were 6 drops of blood in the snow. That's how they collected it right here. Right here. Yep. Nope. It's a police officer's blood. Right there. Yeah. In Solo cups, yes. Okay. He retired, the one we're talking about here. Okay, hold on. What the hell is that? That's annoying. Stop. Here we go. Get rid of this damn thing. Okay. So there is so just so much to go over. We can't go over it all today because it's far too much. But tomorrow we're on verdict watch for Gannon, and I figured I would go over this with you guys. But what I'm going to do right now, because it's just too much detail, right? I'm going to play for you their court appearance so that you can hear what went on this week, okay? I don't even know what this one is. What is that? Sorry. I don't know what that is. Something that I was showing. And wait till you hear this. You're gonna be like, wait, what? It's so much. I just had it on. Hold on. Was all right, you ready? Are you ready?
With regard to the Rule 17 motion for the animal control.
Good afternoon, Your Honor. Alan Jackson from Worksman Jackson and Quinn, along with Elizabeth Little from Worksman Jackson and Quinn, on behalf of Karen Reed.
Good afternoon, Mr. Jackson. Good afternoon, Ms. Little. Good afternoon, Ms. Reed. Okay, so we're here for the Rule 17 motions. Who's going to argue those?
So, Your Honor, there are two motions before the court that we'd like to be heard on. One is the motion to renew our motions to compel, which we'd like to be heard on first, if the court pleases. Okay. And I would be arguing that motion. With regard to the Rule 17 motion for the animal control records, my colleague, Mr. Jackson, would be arguing that second, if the court pleases.
Okay. All right, I'll hear you.
Thank you, Your Honor. May it please the court. We are seeking immediate access to John O'Keefe's clothing, to all evidence seized from my client's vehicle, to tissue and other samples from John O'Keefe's autopsy, and to the original Canton Library video, which we still do not have. We are asking this court specifically to set a hard deadline for access to this mandatory discovery and evidence. Your Honor, at the outset, it is important for me to emphasize why a deadline needs to be set. It's important to emphasize why time is of the essence for our access to this evidence. It's been 15 months since my client was arrested and falsely charged with killing John O'Keefe. Prior to 15 months ago, my client was employed in two prestigious positions. Prior to 15 months ago, she had a robust health insurance plan that covered her numerous serious medical conditions. But 15 months ago, she lost everything. 15 months ago, these false allegations began to destroy her life, and for the last 15 months, she has been fighting for her life. 15 months after her arrest, she has no income. She does not come from a wealthy family. Her father was a respected and now retired educator. Her family is very squarely middle class. But given that Karen Reed is now fighting for her life, whatever money that they've saved is all going to her defense in this case. She's hired private counsel from two coasts. She's hired multiple experts at considerable costs. And when I say considerable, I mean tens and tens of thousands of dollars. And the meter is running with each passing court date. She can't afford to scrimp on her defense because her life is at stake. In the 11th months that this case has been pending in this court, we have continually asked for access to the same basic mandatory discovery evidence. We've been prohibited from inspecting that evidence. In February of 2022, the police seized John O'Keefe's clothing. It's now May of 2023. We haven't seen it, we haven't inspected it, we haven't been able to test it. In February of 22, the police seized pieces of taillight from my client's vehicle, pieces that they claim to have found at the residence where John O'Keefe died, despite the fact that multiple searches initially turned up nothing. Pieces of the taillight were only found after Trooper Michael Proctor, conflicted Michael Proctor, had seized my client's vehicle and had it in his possession for well over an hour. That evidence needs to be put to the test, and it needs to be put to the test now. We have been prohibited from testing it, from inspecting it, from even seeing it. There were tissues and other samples from the autopsy of John O'Keefe to which we've been denied access. We believe that when those samples are tested, the results will be exculpatory, likely case ending. But 15 months after she was arrested and 11 months after she was arraigned in this court, that evidence remains hidden from the defense. The police have maintained exclusive control over the event data recorder and the Lexus infotainment system from my client's vehicle. We have seen neither, and this is simply unacceptable. Prohibiting the defense from inspecting this evidence is infringing on my client's constitutional right to a speedy trial, and it's infringing on her right to due process. It's almost 3 months ago that we last appeared before you, Your Honor. We requested access to these items, and yet again, the response from the Commonwealth was that they would be tested soon. The prosecutor had represented within 30 to 60 days. That's on record. It's now close to 90 days. We've made zero progress. This court did order that the Commonwealth request expedited testing, but that order has yielded nothing. I asked the court to set deadlines then, which the court was not inclined to do. 3 months later, it is crystal clear that deadlines need to be set. Without a deadline, we have no assurances that this case will not drag on who knows how long into the future. With each passing day, my client, who not only is presumed to be innocent, but is factually innocent, remains jobless, with inadequate health insurance, and with each passing day, her savings and her family's savings continue to be depleted. There is no time to wait. There is no time to waste. It is time for excuses to end. As we noted in our motion, the prosecution and the crime lab move very quickly when they want to. In other cases pending before this very court, the very same investigators secured DNA testing within 2 weeks of opening their investigation before anybody was charged. Contrast that with our case, where here we are 15 months later, no such testing has even started. Regarding the Canton Library video, this court should know we still do not have relevant time periods. From the Commonwealth's evidence, we know that my client drove by the Canton Library at 12:16 a.m. on January 29th because that was recorded. There is video of her driving by at that time, heading to 34 Fairview, which is where John O'Keefe died, with her taillight intact. We know that my client arrived back at John O'Keefe's residence at 1 Meadows Ave in Canton at 12:41 a.m. because the Commonwealth produced a voicemail that she left for John, where you can hear the garage door closing, the car door closing, the house door closing while she walked in her high heels on the garage floor. 1 Meadows is about a mile from the Canton Library. We know the video equipment was working because they have that footage from 12:16 a.m. But in the video that the prosecution turned over to us, there is a gap in that video from 12:37 a.m. to 12:39 a.m., which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing. This evidence is strictly in their possession. We've been told that the Canton police provided the evidence to them via a share file, the Canton Library provided this evidence to them via a share file link with a guest ID and a guest password. We need that link, that user ID, and that password. We cannot rely on Trooper Michael Proctor, conflicted Michael Proctor, to sanitize exculpatory evidence before sending it to us. We need the original footage. If the Commonwealth answers that that original footage no longer exists, then we'll need an evidentiary hearing to put the relevant parties under oath to find out what happened to it. The bottom line here, Your Honor, is that we've spent 15 months trying to uncover the truth. We are not afraid of whatever evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However long this case lasts, and I sure hope the prosecution comes to their senses and realizes they have no case because they've charged the wrong person. But however long this case lasts, the remaining evidence will drive a stake through the heart of this prosecution. In the meantime, my client suffers. In the meantime, her life is on hold, while she spends every waking moment defending herself, emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully, to hold the prosecution's feet to the fire. We need this court to order the Commonwealth to stop trampling on my client's rights to a speedy trial and her right to due process. We need this court to set deadlines for the production of this evidence. Thank you.
Okay, thank you. Mr. Lally?
Yes, Your Honor. So, in response to counsel's motion, just in response to the statement that every piece of evidence that's been provided thus far is inconsistent with the defendant's guilt and consistent with her innocence, I would have a large issue with that. But as it pertains to these particular pieces of evidence, counsel's right in that motions were filed. Counsel's right in that motions were allowed when, as related to inspection of said materials, and the Commonwealth has no issue with inspection of materials once they're back from the lab. Now, the last time we were before this court, back in February, the court had asked myself to reach out to the lab and see if there was anything that could be done to expedite the analysis. I did that, spoke with and filed the necessary paperwork with the lab to expedite as much of the analysis that could be done at that particular time. So at that time, what I was provided with was a deadline of no later than May 5th. Those items, at least as far as the trace analysis and the criminalistics was concerned, would be completed, and I should expect something close to that date. I confirmed with the lab as of yesterday that that timeline is still a viable one. The case is currently in technical review, so once that's completed, then we should have reports that I'm able to provide to counsel. As it pertains to the inspection and the return of the items from the lab to the Commonwealth's, well, at least the District Attorney's Office or the State Police's custody, one of the issues that we've had with that is that in order to facilitate some of the necessary DNA testing, some of that testing would be exhaustive. And in particular, there is a hair sample that was recovered from the rear right quarter panel of the defendant's vehicle. It was taken to the lab, and I was informed by the lab that any testing of that for DNA, for comparative purposes to Mr. O'Keefe, would be exhaustive. So on March 10th, I sent counsel a exhaustive testing form that needed to be filled out, whether or not they want an expert present for that testing or don't want an expert present for testing is really immaterial, but I need some sort of authorization from counsel before the sample is subsumed during the course of testing with the lab. I haven't heard anything back from counsel. I spoke to counsel numerous times. I sent emails, and I heard no response as far as that. So as far as the DNA testing is concerned, the delay on that is because I don't have anything back from counsel as far as whether or not they want an expert present, who that expert is, how to contact them, and how to facilitate the beginning steps of that particular testing. So that is why at least in no small part, why some of the items are still contained at the lab is because the testing is still yet to be completed. But I do hope to have the trace and the criminalistics, and I expect that by next week at the latest. And again, whatever deadlines that the court sees fit to or deems fit to put on certain things, as far as that's concerned, is certainly within the court's prerogative. I don't think that we need deadlines. I don't think that we need an evidentiary hearing as it relates to it, but that's where it stands. As far as the video is concerned, the video was provided by the IT director for the town of Canton. There was a share file that was shared with the troopers. The troopers, upon receiving that, it was Trooper Dunn who received that video, not Trooper Proctor. If I could just speak Briefly, as it pertains to Trooper Proctor, there is no conflict. Trooper Proctor is not conflicted in this case. I indicated that specifically in some of the oppositions that were filed to the Rule 17. So there's been some photograph taken from a social media site which is purported to be Trooper Proctor with one of the McCabe's children who were a witness in the case. The child that's depicted in that particular photograph is not one of the McCabe's children. The McCabe's have 4 daughters. That's not one of them. It's a relative of Trooper Proctor. It has nothing to do with the McCabe's and nothing to do with this case. Whatever conflict counsel believes Trooper Proctor has just doesn't exist. Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days, within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
Okay. All right, your next motion?
That would be Mr. Jackson.
Okay.
Good afternoon, Your Honor. May it please the court. We are, as indicated in our papers, we are seeking summonses, and this is dealing with the animal control issue, that Rule 17 motion. We're seeking summonses directed at 2 entities, the Canton Animal Control and the Canton Town Clerk, both. We believe they both have records. We know they both have records. These are records that we need, the defense needs, to shine a light on Karen Reed's innocence. These are records that are central to our theory of the case, and these are records that we have no other option to get but through a summons. They've indicated to us they have the records, but they need a court order. They need some sort of a summons. Your Honor, in furtherance of this motion, I want to talk for a quick second about a couple of undisputed facts. Undisputed fact number 1, on January 29th, 2022, Officer John O'Keefe was found dead in the yard of Brian Albert at his house at 34 Fairview in Canton. That is undisputed fact, where he was found dead and what the circumstances were surrounding that death are why we're here now. Second undisputed fact, when John O'Keefe was found, he had this set of wounds on his right arm. The medical examiner indicated that these wounds were concomitant with his death in terms of the temporal, the time that he died. These were wounds that he suffered at or near the time that he died. And the Commonwealth looks at these wounds and says, there's nothing to see here. Why are we looking at this? This is, you're following a red herring, basically. This is just a road rash. This means nothing. It has no impact on our case one way or the other. This is, according to the Commonwealth, simply a set of injuries that John O'Keefe suffered at the hands of being struck by a moving vehicle. Well, first, I would ask the common sense question, does this look like a road rash? I mean, the court's got years, decades of experience, life experience and legal experience. Of course this doesn't look like a road rash. It's not a road rash that any of us have ever seen. Or does it look more like claw marks and bite marks from an animal, which is exactly what they are? Second, if it was a road rash, where's the rest of the road rash? John O'Keefe had one set of injuries like this. Deep scratches, deep puncture wounds on his arm, on his right arm only, from mid-biceps to mid-forearm and no other place. For instance, mid-biceps and mid-forearm that you might put in front of your face or your body if a large animal was attacking you, resulting in these wounds. Why are the wounds confined just to his right arm? What about all the other pointy bits of a human body? If someone is rolled under a car or rolled in gravel because of the car, what about the shoulders? What about the knees? What about the ankles? What about the elbows? None of that exists. These are the only wounds. They're confined to his right arm, and they're deep scratch wounds, puncture wounds that are indicative of claw marks and bite marks from a large animal. And third, what about the Commonwealth's own expert? She has to have opined about this, correct? She has to have said during the grand jury, this was a full-throated investigation surrounding the potential murder of a police officer. What does the Commonwealth's own expert say? First of all, she was never asked by the Commonwealth during the course of the grand jury about the injuries. It took a grand juror actually asking the question of the witness, and she said, no, I cannot say that is a road rash. There's certainly not enough evidence to suggest that these wounds are consistent with a road rash. Well, she had to have at least talked about the fact that it was an animal, right? She had to. The Commonwealth had to have asked that question. She actually said nothing about whether or not that's consistent with an animal, because the Commonwealth very particularly did not ever pose that question. But we did. We hired one of the preeminent medical examiners in the country, a doctor by the name of Sheridan, Frank Sheridan, and he wasn't some deputy medical examiner. Dr. Frank Sheridan was the medical examiner for San Bernardino County in California, with more than 12,000 autopsies under his belt, the supervising medical examiner for one of the largest counties in California, and he concluded to a scientific certainty that these wounds are from an animal attack. Period. Full stop. So, what do we know about animals and the Alberts? Which is exactly where Officer John O'Keefe was found dead. In February of 2017, we know that the Alberts had a dog. There's a photograph of Brian Albert with a dog, Chloe, in the foreground. By 2019, the Albert family had registered ownership of that German Shepherd. Moving on to 2022, in January of 2022, specifically January 29th, John O'Keefe suffers these animal puncture wounds, these animal scratches, these animal bite marks that are heretofore and up to this date, today, completely unexplained by the Commonwealth. By May of 2022, Karen Reed's defense team starts asking questions about this animal, about these injuries, about the dog, about what dog existed at the Alberts house. Where is the dog? We started inquiring pretty significantly. That same month, amazingly, the Alberts informed the Canton Animal Control that the dog was remarkably and mysteriously rehomed. The dog was gotten rid of. And to date, the Commonwealth has yet, as my colleague just mentioned, has yet to release the tissue samples to us for DNA testing to determine if there's evidence in these wounds of a canine attack, which we believe there will be. During that grand jury testimony, Brian Albert admitted to three things. Number one, he admitted that he owned a large German Shepherd. His words, not mine. A large German Shepherd. Number two, he admitted that the dog was at his home on the night John O'Keefe, early morning hours, John O'Keefe was killed on January 29th, 2022. And the dog, according to his own testimony, was inside the house and never in the front yard, which is where John O'Keefe's body was ultimately found. And the third thing that he admitted was that the dog was, quote, not great with strangers, end quote. That's a dog owner's euphemism for the dog bites, the dog attacks, the dog is mean or can be mean. So why wouldn't the Commonwealth ask about these injuries? Why wouldn't the Commonwealth inquire, as we have been inquiring, about the nature of these injuries and their significance in terms of John O'Keefe's death? It's because they know that the answer completely obliterates their case. Their theory of homicide would fold if they got the true answers to these questions. The answer exculpates Karen Reed, and the answer inculpates Brian Albert. That's because if that dog was inside the house that night, not on the front lawn, not in the front yard, but inside the house, and these injuries were suffered or sustained at the time John O'Keefe was killed, then that means John O'Keefe was inside the house when he was killed. And it also means that his body was moved. That's consistent with the facts that we also know to be true, which is not one person that was in that house and ultimately exited that house from that party that night, not one, saw John O'Keefe's body laying in the cold in the front yard. And that's because he wasn't there yet. Multiple people walked out of the house, multiple people who would have no other reason, would have no reason to lie about that. A 200-pound man, 6'2", lying in the front yard on a light dusting of snow in dark clothing. Not one person saw him. But if John O'Keefe was beaten unconscious in, for instance, the basement of that house, and later moved to the front yard after the guests had left, there's your answer as to why no one saw him. And it also answers two other questions which are looming in this case. Why would Brian Albert rip out the floor of his basement months after John O'Keefe was killed? The second question, why would he sell his house? So in the months following John O'Keefe's death, the dog has been gotten rid of, got rid of the evidence in the basement, got rid of the house, the crime scene itself. Your Honor, I would submit to the court that evidence is literally being destroyed right under our nose. It's been reported that the federal authorities have now gotten involved in the circumstances surrounding this case and have impaneled a federal grand jury to investigate some of these circumstances. But Karen Reed should not have to wait for the feds to figure out which heads should roll. I would implore the court, now is the time for the court to take some action and give us the tools, the defense the tools that we need to fully investigate this case. We need these records to track down this German Shepherd, if it's still alive, which clearly is an open question. Our understanding is, at least up to this point, is that the dog was not only rehomed, but rehomed out of state, out of the jurisdiction of this court and out of the reach of the defense, or at least that was the attempt. We need those records to find where that dog is. If the dog still exists, we need a saliva sample, we need a hair sample, we need something, and then we need the Commonwealth to give us the tissue samples that were taken at the time so that they can be compared. This is vital to the defense. We ask that the summonses at issue for the two entities that we've described, that those summonses issue. Our request clearly meets the Lampron standards. Number one, it's relevant evidence. Number two, we definitely need a subpoena or a summons. They will not provide the information without a court order. Number three, this information is necessary for our defense. And number four, contrary to what the Commonwealth constantly says, oh, well, this is just fishing, I think we've established this is not just fishing. We got a fish on the hook. We just need the court to help us reel it in. I will submit on further oral argument regarding the issues or the summonses surrounding the animal control and town clerk. If the court has any further questions about those, I'm happy to answer them. If not, I can certainly give the court a preview of the second Rule 17 motion, which deals with the phone records and the actual phone of Brian Albert. But I believe the court has indicated, and we've suggested, that an evidentiary hearing is in order.
As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you.
That's perfect.
Okay.
The only thing I would say in furtherance of that, very briefly, is the Commonwealth has suggested that Rule 17 is just sort of a regurgitation of something that we filed back in, I think it was September, that could not be further from the truth. There is new information. There's dozens of pieces of new information that we have.
What I'm going to do because of that, let's let Mr. Lally respond to your remarks on the question first.
Thank you, Your Honor. Your Honor, first I would state it's an interesting sort of straw man argument as far as it being road rash, or that the Commonwealth has always maintained that it's road rash on his arm. No one has ever said that but counsel for the defendant. As far as the injuries are concerned to Mr. O'Keefe's right arm and right forearm, they've always and consistently been described as abrasions caused by blunt force trauma, not road rash. I'm not really sure where the road rash comes from. What I would submit in conjunction with that is, again, divorcing whatever evidence the defendant claims from the context of the rest of the evidence and the rest of the case. It's a little peculiar and conspicuously clear from the defendant's fact section that the damages to the right rear corner panel of the defendant's vehicle, embedded within the bumper to that vehicle, is pieces of a cocktail glass. The victim, Mr. O'Keefe, is last observed on surveillance video, external surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. The same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car. As the court is well aware, and I just stated for the record, under Rule 17, the defendant has the burden, or the moving party has the burden to establish that the documents are evidentiary and relevant. Secondly, that they are not otherwise procurable reasonably in advance of trial. Thirdly, that the party cannot properly prepare for trial without such production and inspection. And fourthly, that the application is made in good faith and is not intended as a general fishing expedition. The issue that the Commonwealth takes with the defendant's request as it applies to these particular records is with number 1 and number 4. The Commonwealth would submit that the showing from the defendant is simply insufficient to establish any relevancy or evidentiary value to these records. And then secondly, that this is the very epitome of a fishing expedition. The indication, even from the verbiage that's used by counsel in the motion, sort of sheds light as far as as I just stated, the sort of epitome of a fishing expedition. It's language such as "it could shed light," or "if true, this fact would undermine the prosecution's entire theory of the case." There have been a couple of theories that are stated within the context of counsel's motion. I can state for the record those are not the Commonwealth's theories. No one ever said that the vehicle struck Mr. O'Keefe in the head and that's what caused the injuries. That's actually not at all what the grand jury testimony or the evidence has shown throughout the course of this investigation and throughout the course of this case. But those "could" and "if true," those very words by definition evince the very nature of this particular request. The first issue would be with the time frame. As it's stated within the motion, it's from 2015 to present. I'm not sure why so expansive a time frame is needed or necessary or relevant to anything that is a subject matter before the court. As counsel suggests, that photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face as well as to the back of his head, that there's evidence of defensive wounds, there's a cluster of deep scratches and puncture wounds to his upper arm and forearm, and then the defendant essentially asked the court to take the then inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Samaritan, where Mr. O'Keefe was taken immediately from the scene where his body was discovered, and from the medical examiner's finding and sworn testimony. So wholly inconsistent with those, that these are, then take the inferential leap that these are consistent with bite marks or scratch marks from an animal, specifically a dog. In support of these assertions, as counsel stated, there's an affidavit from Dr. Frank Sheridan that the injuries are consistent with animal claw or scratch marks.
Well, we've had an interrupt in the feed there from
His eyes being related to the fractures in his skull and how those manifested into the observable swelling and discoloration of his face. And essentially what she testified to was that there was a laceration on the right back of Mr. O'Keefe's head, that there was a skull fracture in that immediate area, the right parietal area of the victim's skull. That then caused a swelling on the brain, which she observed, as well as Dr. Stonebridge observed during her neuropathology examination of Mr. O'Keefe's brain post-mortem. That then caused the swelling underneath of the skull, caused the radiating skull fractures that she observed in Mr. O'Keefe's skull throughout, and that the essentially nowhere else for the blood to go, and the looseness of the vascular tissue behind the eye then causes both of the eyes to swell. There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds. She was specifically asked those questions and testified to that before the grand jury as to those injuries and how they sustained. There's absolutely no evidence that Mr. O'Keefe ever entered the residence at Fairview on that particular evening. Counsel mischaracterizes some other statements made by a witness, Mr. Brian Nagel, who had come to pick up his sister at the residence. She came out, he observed that vehicle. He observes that vehicle from the entirety of the time that he's there. So he's pulling on to Fairview. Ms. Reed is coming on to Fairview in the opposite direction. The right blinker on and a left blinker on. The operator of the vehicle that Mr. Nagel is in then essentially flashes its lights and allows Ms. Reed to pull in first. So Mr. Nagel is there the entire time that Ms. Reed pulls onto the street when she pulls up. Indicates that she initially pulls over to the right-hand side of the curb, then pulls the vehicle forward a little bit further. That's corroborated in testimony from a number of different people who were inside the house, as well as Mr. Nagel's sister, who then came out of the house and talked to her brother at the door of the truck that he was riding. Mr. Nagel further indicated that at no point did the brake lights come off, including the center top light of the SUV that he observed in front of the house. There were no footprints outside of the vehicle. He never saw anyone exit the vehicle. No one in the house reported ever having anyone come inside the house or seeing anyone exit the vehicle. And I'm a little confused just as far as counsel's statements, as far as the multiple people saw Mr. O'Keefe or never saw Mr. O'Keefe come into the house. Or if he comes into the house and he's attacked by the dog, I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house? It's consistent throughout the entirety of all the witnesses. It's consistent with Mr. Nagel as well. It's consistent with the forensic evidence. It's consistent with every piece of evidence that has come to light at this point. And there's further statements in regard to the dog. Some reported incidents several months after the death of Mr. O'Keefe. The counsel suggests ineluctably that the animal was violent and prone to violence from one incident that postdates this particular time frame of Mr. O'Keefe's death, and seems to punctuate that this circumspection on and on about how violent the dog is from an incident that he has no information about, whether or not it involved another animal, whether or not it involved another human, whether or not it involved what exactly the incident occurred. This is simply not what Rule 17 is to be used for. That's what the case law has consistently held, is that it is not a discovery tool. It is based on information, relevant evidentiary support, which is completely and utterly lacking in this particular motion, in this particular submission. So for those reasons, the Commonwealth would request that the motion be denied.
Okay. So the second Rule 17 motion, are we going forward on that and then having the hearing regarding the timing of the video? How are we going forward with this before I hear from you on the substance, Mr. Jackson? What is the next date for?
May 25th.
Right. What's it for? The evidentiary hearing?
Yes.
All right. So do you plan on arguing your Rule 17 motion today or that day? Not both?
That day.
Okay.
I'd rather reserve and
That
argue
makes sense to,
17th that day.
that makes sense to me as well. So we're finished for today, unless there was any follow-up to Mr. Lally.
There
I'm not
is.
going to hear a preview on the motion that we're going to hear on that day.
That's fine. I do have some points to make.
Okay, I'll hear you on that.
Thank you. With regard to the dog, first of all, I think the Commonwealth misses the point. If there was a fight inside the house with the dog's owner, the dog would likely attack. That is the idea that is borne out by the evidence that we have. We know that he was beaten. We've got evidence that John O'Keefe was beaten, that he lay there unconscious. And we also have evidence that at the time he was beaten, facially, and blunt force was used against the back of his head, he was also attacked by an animal. Well, Brian Albert, who's a known fighter, owns a 90-pound German Shepherd that has since been gotten rid of and had a skin-piercing incident as the excuse for having gotten rid of it. So we know that the dog attacks, according to sort of uncontroverted evidence. We weren't saying, and we don't suggest, that the dog killed John O'Keefe. We're suggesting that the dog was there when John O'Keefe died and also attacked John O'Keefe. That's the point. This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. That makes absolutely no sense. It just doesn't pass the sniff test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there while she jumps in the car, slams it into reverse, then hits him with the car, with her tail light in the back of the head. It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck. This looks like an animal attack because it is an animal attack. And it's at the same time, temporarily at the same time, that he was otherwise beaten and then ultimately left for dead. Interestingly, it's interesting that the Commonwealth doesn't mention the basement in their arguments. I mentioned the basement because that's very likely exactly where John O'Keefe went once he walked into the house. There's no evidence that John O'Keefe walked into the house. The Commonwealth has evidence that John O'Keefe went into the house. They haven't. They just sat on it for several years, or for several months, over a year. That the Apple Health data from John O'Keefe's own phone establishes that once he was at the location at 34 Fairview, he climbed 3 sets of stairs. The Albert house happens to be 3 floors, a basement, a middle floor, and an upstairs. His Apple Health data also shows that he took multiple steps after he left the car, after he left Karen Reed's vehicle. The multiple steps indicate that he was in the house. If, in fact, the Commonwealth were correct, and he stepped out of the car, was hit by the car, and fell down and died, if that's what their theory is, he would have no Apple Health data suggesting that he was climbing stairs and walking about as if he were inside the house and was ushered down to the basement, at which point there was a fight, he was beaten to unconsciousness, and then everybody in the house leaves, not having to go down to the basement. There's a door that services that basement that's closed. So there's no reason for people who are upstairs, either upstairs or on the main floor of the house, to even know that there had been a fight downstairs, or that John O'Keefe never made it out of the house alive or conscious. With regard to Ryan Nagel, the Commonwealth leaves out probably the most important part of his testimony. Ryan Nagel's testimony is that he arrived just after Karen Reed arrived. They arrived not at the exact same time. She turned down the road. Then he turned down the road. As he approached the road, as he approached the house, he then pulls to a stop. He had her car in his sights the entire time, just after she had already arrived. Certainly time enough for John to get out of the car and walk toward the front door. He said that he observed that there was no taillight damage whatsoever. He later observed inside, either through a dome light or through other ambient light, that he could see inside the passenger compartment of her car, and that she sat there alone. And most important, he didn't see her hit anybody with her SUV. That's the most important part of Ryan Nagel's testimony. He didn't see her hit John with the car, which he would have had to have seen if he was situated right behind her. And the Commonwealth has repeated what they've oft repeated several times, which is there was no sign at all of any kind of an altercation or fight. Well, if there's no sign of an altercation or fight, how can he turn around and say that a cocktail glass did this? I mean, they can't talk out of both sides of their mouth. How could they reasonably ignore two black eyes, a laceration over his right eye, a laceration at his nose? He looked like he had gone 10 rounds with Mike Tyson, as my colleague has once analogized. Of course there's evidence that he was in a fight. The back of his hands, deeply bruised. Those are called defensive wounds. I don't care what their medical examiner called it. Anybody who's seen any sort of a fight, a street fight, knows that the back of the hands, the back of the arms, get the brunt of the punches as you cover your face. Of course there were signs of a fight. Not just a fight, a brutal fight. And what does a dog do when its owner is in a fight? What does a German Shepherd do when its owner is in a fight? Reaches out and attacks and supports his owner. And what does a person do when a dog attacks? Usually puts his arm up, his dominant arm up, to protect himself. And that's where the lacerations, the bite marks, the claw marks appear on John O'Keefe's arm. This is not a fishing expedition. The Commonwealth has an unreasonable expectation. They cite to words that we use what the evidence might show, what it could show, what it potentially will show, as a weapon to say, well, see, they don't know what the records are going to show. Well, if I knew what the records are going to show, I already have the records. I wouldn't need the court to ask for them. Of course I don't know everything that's in the records. And the reason that we asked, Your Honor, for 2015 is because we have evidence that in 2017, the dog looked full grown. So we wanted to go back and bracket the proper amount of time. If say the dog was a couple of years old at the time that photograph was taken in 2017, we want all the records associated with that dog, which means we bracketed our request. It's not overly burdensome. It's certainly not burdensome to the Canton Animal Control, and it's not burdensome to the Canton Town Clerk. And if the records don't exist, because they just don't, they're too old, then no harm, no foul. But that's why we bracketed our request to go back from 2015 to present. And with that, Your Honor, I believe that we have made a good faith showing. We have met the standards of Lampron, all four standards of Lampron, and the summonses should issue. And also.
All right. Anything else, Mr. Lally?
Just briefly, Your Honor, as it pertains to Commonwealth would agree that attributing the cuts on Mr. O'Keefe's arm in their entirety to cocktail glass would be somewhat ridiculous. That's not what I said, and that's not what I was attributing them to. And I think the court understood that, but just so counsel understands that as well. As it pertains to Mr. Nagel, what is in his testimony is that he had the vehicle, they arrived at the residence in tandem. The vehicle was there when Mr. Nagel left. So while he sees no one exit the vehicle, no one enter the house, and no one else sees anyone exit the vehicle or enter the house during that specific time frame, the defendant, and presumably Mr. O'Keefe, are still there and still in the vehicle at the time Mr. Nagel leaves the house. That was the point that I was making with that. As it pertains to the Apple Health data, and obviously we'll get into this a little bit more when it comes to that subsequent Rule 17 motion, the Apple Health data is the same Apple Health data that's being relied upon for the supposition that Mr. O'Keefe went inside the house. That same Apple Health data has, among other things, Mr. O'Keefe taking 46 steps and traveling a certain bit of distance around 11:56 a.m. on January 29th. The problem with that is that he was pronounced deceased at the Good Samaritan Medical Center at 7:50 a.m., some 4 hours prior to that. In addition to that, from the information as far as when that ascending or descending of stairs occurred between, I believe it's 12:21 and 12:24 a.m., there's a Waze search and location data from Mr. O'Keefe's phone. The Waze search is conducted, and the GPS location information from Mr. O'Keefe's phone shows him en route to the house and not arriving at the house until 12:24 a.m. So the information the counsel is relying on has him going up and down 3 flights of stairs before he's even at the house. So for those reasons, again, the Commonwealth would submit that the defendant has not met its burden and ask that the motion be denied. Before we do conclude, I just did want to remind the court there are a couple of other issues that I need to address with the court, specifically the Commonwealth's motions to impound and the Commonwealth's motion for access to the defendant's phone.
Okay, I'll hear you.
So there were 2 motions to impound that the Commonwealth had filed. One pertains to the grand jury transcripts and exhibits that I had attached as attachments or exhibits to the opposition to this specific motion, and really to both motions.
And those are impounded by statute.
Right. The other motion to impound that I had filed pertains to the attachments to the defendant's Rule 17 motion pertaining to Mr. Albert's cell phone and the call detail records of Ms. McCabe and Mr. Albert. Now, certainly, the Commonwealth is not saying in any way, shape, or form that those items shouldn't be submitted. The defendant can submit whatever she wants, whatever counsel wants in support of that request for the court to review. But the manner in which the information is released, and specifically what I take issue with, and I'd be remiss if I didn't say this on behalf of the O'Keefe family.
I'm not sure I'm not sure they hear you.
Okay. In reference to the motion to impound the attachments to the defendant's Rule 17 motion for Mr. Albert's phone and the call detail records of Mr. Albert and Ms. McCabe, I'd be remiss if I didn't, on behalf of the O'Keefe family, as well as just what the statutory rules are, and specifically I'm talking about the Supreme Judicial Court, Rule 124, pertaining to protection of personal identifying information and publicly accessible court documents, which I would imagine that at least Mr. Unetti, even if Mr. Jackson and Ms. Little aren't familiar with, does provide rules as to how things are filed that are of that kind of sensitive nature and that kind of biographical information. And they're routinely filed with the court with a motion to impound or a motion to seal and not filed directly with the media. The issue being that there are photographs depicting Mr. O'Keefe's postmortem at the Good Samaritan Medical Center, as well as possibly some autopsy photos that should have been impounded. There are unredacted Canton Police Department reports, multiple copies. Again, not anything that Commonwealth takes any issue with the court reviewing, but as far as them being made public with those witnesses' names, dates of birth, social security information, addresses, phone numbers, things of the like that should be impounded pursuant to the statute as well. And in particular, I do take issue with that motion, specifically on page 11. There is a specific reference made to the name of the decedent's niece, which is strictly prohibited as far as being provided in a public document. So for those reasons, I would ask that the attachments to that motion, to whatever extent it can be at this point, given the public release of them, be impounded.
Mr. Unetti?
Your Honor, I believe that some of that information may be in the public domain already, so it may be that the cat is out of the bag with regard to some of it.
It is now, right?
I'm sorry?
It is the cat's out of the bag now.
Right, yes. So, I mean, we're agnostic on this motion to impound. We have access to it, the Commonwealth has access to it, and most importantly, the court has access to it.
All right, so by statute, everything that was raised by the Commonwealth was supposed to have been requested to be impounded at the time it was filed. So that was not done.
Are you talking about the motion that we filed with regard to the Albert phone motion?
Yes, the attachments. Mr. Lally just outlined it.
I don't think that there were any grand jury minutes attached to that motion.
No, that was a separate motion that Mr. Lally just
Right.
filed on behalf of his motion.
Right, and we don't have-
When he was taking issue with the defendant had filed.
Right. Okay. Yeah, again, we don't have an objection at this point.
All right, Mr. Clerk, those are both allowed. All right, is the hearing, those are both allowed by statute. So is this hearing over?
Your Honor, if I could just address, the Commonwealth had filed some time ago a proposed procedure regarding communications stored in the defendant's iPhone. So we had addressed this briefly, I think, on the last court hearing date in February in relation to the defendant's phone. So the defendant's phone was seized lawfully from her pursuant to a search warrant. The information contained therein was then downloaded. Upon a cursory review of that information, there was an indication that there was some communication between Ms. Reed and Mr. Yannetti contained within the information within that phone. So obviously all examination of Ms. Reed's phone from the Commonwealth's perspective ceased at that time. And we had begun exploring and filing this motion. I had it in hand to file with the court on the last date. However, after several discussions with Mr. Yannetti and counsel for the defendant, I was then informed in court on the last date that the AFE or the independent sort of forensic examiner that would look at that phone was believed to have some sort of conflict. It was not acceptable to Mr. Yannetti. So there was a separate person who essentially runs the lab at the Attorney General's office, who I spoke to Mr. Yannetti about whether or not that person would be acceptable. He does have a conflict, just so the court is aware, as far as grew up in the same town as the victim and his siblings. But Mr. Yannetti indicated that he, at least verbally to me on that date, that he didn't see any issue with that conflict, as the person would just be assigning it to a couple different forensic examiners within his office. I then modified the motion to incorporate that subsequent AFE, sent a copy of the motion to counsel 6 weeks ago or so, and still received no response. So what I'm looking for today is action on that. The other thing that I would note for the court is that counsel had asked for a raw extraction copy of the material from the defendant's phone, which was then provided to counsel on March 22nd. So for over a month, the defendant has had access to the defendant's phone and the Commonwealth has not, because counsel has failed to respond to whether or not the AFE was reliable or not. And what I was referencing on the last court date is the court had indicated that if we were to come to some sort of agreement, the court could act on the papers and obviate the need to address it on this date. It hasn't happened. I would submit that the proposed protocol was more than reasonable, and I would ask that it be allowed by the court.
So, Mr. Yannetti?
Yes. I was the one to suggest that it be analyzed by the Attorney General's Office, Cyber Crimes Division. I thought that was clearly, we have no objection to that, but I'll announce it in open court. We have no objection to that. The motion for the protocol, procedure is agreed to.
And you're okay with the individual that was cited in it?
Yes, the individual who was cited in it is the head of that unit. I know who he is. I respect him. He revealed to me at the start that he has a personal conflict. I have no issue with him assigning it to somebody in his office.
Okay. So the motion's allowed by agreement?
That's fine.
Okay.
Okay. There's no way that that guy can take on these guys. Yeah? You're finished? You're already done? Yeah. Okay. Yep. Did you turn it off? Are you done with your bath? Yes. Okay. Kids are so funny. It's like, I'm done. He did have a head injury as well. Yes. Let me see. Let me show you. Here are his injuries. They're saying this happened from her making this turn. Not a chance. Look at these ones specifically, okay? That is not from a car backing into you accidentally. That's not from a car hitting you and running you over. Right? And yeah, he does have a head injury as well. These are his hands. It's his hand. That's his laceration to the back of his head. Looks like a dog bite. I have enough dogs to say, looks like a dog bite to me. I don't see it. So, tomorrow we are going to continue with this. Okay. And it is detailed, and there are no cliff notes. I don't like cliff note cases. I don't like cases that you can sum up in 20 minutes. Because they're important and they involve people. So, if those long ones don't interest you, then don't tune in tomorrow. But if you want to see what happens or what's happening and what these people said, then while we are on jury watch, on verdict watch tomorrow for Gannon, we're going to go over this. She wasn't even allowed to go to the funeral. It's insane. Definitely looks like a puncture wound, for sure. So we're going to go over it all tomorrow. Probably start around 10:30 in the morning or so. And I will see you guys then. Long one's the only way to go, Jenny. Yeah. Complicated. Idaho 4, no offense. I mean, he did it, in my opinion. Right? Brian did it. What am I talking about? I don't know. Nothing. What can I talk about? They did say the FBI is looking into this case, but the FBI doesn't comment on those things. So, yeah, for sure, Jax. And I mean, there's not, there's a long history of crazy that we could get into, but that'll lead us down a road of corruption and police stuff that we probably don't want to go into. But because there are so many people and there were so many people at the house, I mean, let me see something here. Like this. Brian, Nicole, their son, their daughter, their nephew, 2 friends, Jennifer, Brian, a federal ATF officer, John, and Matthew. There are a lot of people there. So here's the mailbox. And from this view, There's also a flagpole. So let me do one thing here, okay? Let me see if I can do it this way. Okay, man. All right. So this is the house here. Why does it look crazy? What the hell happened to Google Earth? What are you, nuts? Why the hell does Google Earth look like that all of a sudden? Nutty, right? Get it together. Okie dokie. Sheesh. Alright. So this is a big ass lawn. I wish, maybe I can do street view. Come on. Put me on the street. Go ahead. Now. It's a little slow. My resources are a little slow right now. Here you go. Here's the flagpole, right? There's the flagpole. Here's the house. Here's the clump of trees, right? Here's the mailbox. And it's winter. It's starting to snow. We're not having a blizzard yet until the next day. But you gotta walk down here. You don't see him laying here? You don't see him there? Here's the driveway, right? She's looking. She's in the doorway. One of these two, I don't know which one. Right? McCabe. Looking out down here. Says park behind me. Sees her pull over here. This way. Makes a 3-point turn. This is not a tiny road. So you pull out. You go like that. You pull back. You pull out. Done. What's the problem? I don't get it. You know, and thank you, Bonita. How old were they? I can tell you it's on the other thing, but it is crazy. They did them super dirty. But it doesn't make sense. If you're coming out of the front door, even if you're coming out of this door, right? Because if your cars are parked down here, because there were a lot of people there, right? It wasn't just a couple of people. And we'll get into that in more detail tomorrow too. But, so you can come in from this way here. You drive up. You can park behind. No problem. Nobody sees him laying out here. Nobody. How? How don't you see him? On a white ground. He's in dark clothing. He's 6'2". Nobody sees him. I don't know. It's not like he was found in here, you know, up here somewhere. He was out here. My understanding is, you know, there's a clump of trees. Here you go. What street did they say that, let me see something. Chapman Street. Hold on here. So were they coming from this way? I think they were. I'm going to guess that this is Chapman Street. Is it? I don't know. What's this street here? Cedar Crest. So maybe Chapman's the other way. That's Cedar Crest. All right. Chapman down here. Right here. Right? Carriage. Carriage Lane. How far away is Chapman, for mother's sakes? That's a dead end, so they weren't fucking coming from there. Give me a break. Where's Chapman? North Carolina. No, dummy. Oh, so funny. It's looking for it too. Oh, there is one. I didn't know there was a Canton, North Carolina. That's funny. So funny. Wrong place. Hey, Deets. That's what I'm wondering. What would have obstructed their view? So let's see. Chapman Street. Come on. So slow right now. It's getting there though. I wanted to see it in real time, but ain't nobody got time for this. I'm too impatient. It's probably Chapman Street, Canton. All right. One minute. So they turned on Chapman and went up there. Okay. Okay. Oh my God. 8. Are you kidding? Why is this so slow, bro? It's the worst. Look at the trees. They look crazy. Crazy trees. So they come up there, here, straight up. Oh, I see. Okay. Looks like we're playing Minecraft, right? Looks like Minecraft. I'm gonna build something. I'm gonna build a house. Oh, you heard me mention Ganon? Yeah, we're gonna watch that tomorrow, so. Or we're gonna be waiting tomorrow. Waiting and waiting and waiting and waiting and waiting. You guys think it's gonna be back on? Do you think that they're gonna have a verdict tomorrow? I don't know. I hope that they're gonna have a verdict tomorrow, but you don't know. You never know. Hopefully. But I don't think that people expected it to go past Friday. This would be a great feature if you need to paint trees from the either. Yeah, that's true. You think that there will be one tomorrow. I hope there will be one tomorrow. I mean, we're going to see, right? We're going to see. But we're going to go over the whole Commonwealth, all the paperwork that they have tomorrow, so. Highlights and shadows. I know. Will all be, what's the guy with the big hair? Let's paste some nice little trees. What the hell's his name? The guy? You know what I'm talking about. The nice man who paints nice trees. I think they will have a verdict Wednesday. Oof. Wednesday. Oh, boy. I mean, they probably, they have all weekend that they got to think about this now. But it's crazy to me, too, that such a big case and they're going home, Bob Ross, that they let them go home. I mean, I guess they couldn't sequester them, but. Oh, I know, Deets, already. I know. I didn't check it, but I know. Bob Ross, yes. All right. Off I go to, oh, it's 7 o'clock. Shit. Make sure this kid dried himself off and emptied my tub without destroying my phone that he was using. But we'll be back on tomorrow at 10:30 because we're